My steam's been coming off my bald head all night. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay.
And now I have been made to look like an idiot. I do not believe that this trial should continue, Your Honor. I don't even know what to say to my client, Your Honor. What do I say?
I don't know. Obviously, I don't know what to say right now either.
Day 103 of the Young Thug YSL RICO trial was insane. Defense lawyers are appalled because the court let them know of another ex parte meeting that was kept secret. Brian Steele also wants the judge to reconsider his motion to dismiss. Defense lawyers are very upset today. At one point, Max Shard even says his bald head has been fuming all night. And they have the right to be. It's another secret meeting that they weren't notified about or anything. Brian Steele also wants her to reconsider his motion to dismiss later in this video, so stick around for that. Channel membership is only 10 cents per day. Love you guys. Here we go. First look at Thug on day 103. Got the hair down, looking tired like always.
We'll have ready soon any kind of potential instructions for what we're going to be telling the jury about either Mr. Copeland's testimony.
Dude, what are they going to tell the jury? This is such a shit show, man. Like, I don't understand what they're going to tell the jury. Hey guys, we're going to pretend like you don't already know the judge and the prosecutors coerced Woody to testify.
And then I'll entertain what we're going to, I am going to say about the fact that here I am instead of Judge Glanville. But I mean, for that, I'm thinking essentially just, I don't know, some matter has required a substitution of judges, and that's about it. I don't plan to tell them really much more than that. They don't need to know why.
What? They don't need to know why? They're going to be so lost. Well, they already know. They've been watching on social media.
I'm objecting to anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth, that he has been found to be disqualified and removed from his case for his conduct. And that's my instruction that I worked on.
All right, well, I'll consider everything once I've got everybody's proposed instruction to the extent anybody wants to provide one for me to think about.
So Brian Steele objecting to them trying to hide that the judge was disqualified. Trial really is broken.
Yesterday, we received a transcript.
Oh boy, here we go. None of these defense lawyers are happy about the transcript, obviously. An entire new meeting happened on the Friday before the Monday of the big ex parte meeting they didn't know about.
A transcript of an ex parte meeting that occurred on Friday.
Right, this is
before the Monday.
Sorry, just so that we're clear for the record purposes. This is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had an in-court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
Let me be more artful. Yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We're not told by the state, we're not told by the judge that had occurred. We found out about it, luckily, then demanded a transcript, complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th. We sat there after finding out about one ex parte meeting and having to drag the truth out. We sat there and the state and their co-conspirator, the trial court, about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Kayla Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in his ex parte meeting, yes, I've observed these things. The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel. People have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And in that transcript, the trial judge, who's is not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is.
How does this go on? How do we continue like nothing happened? The jurors are going to be confused. And they were already confused about how much witnesses they had to remember. They're like, I don't remember anything from a month ago.
Right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. The bottom line is there's a lot more discussions that need to be had about this. Do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions.
Right.
Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's not okay. It's offensive, and it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My steam's been coming off my bald head all night.
I don't think there's ever been a trial more where the bald head comment comes up.
Nothing about this is okay. Yes, we need to revisit everything. That's my stance.
Okay, thank you. And I understand you being upset, and I understand why you and probably some of your fellow defense counsel on this side of the room are upset. I do not think that everything you said is a fair characterization of what that June 7th transcript reflects, but once we have the official copy, that'll be made a part of the record, and that will show what actually happened, what actually was said. As to any kind of legal error that may have been made with regard to rulings prior to Mr. Copeland's testimony, assuming this case goes forward and assuming there is any kind of conviction, I then assumed that there will be a motion for new trial phase, which at that point I can appropriately revisit things, and then potentially an appeal, at which point those things can be raised. Consider again all of the evidentiary rulings with regard to the videos and audios that might be used with Mr. Copeland, because that's the witness that we are on the stand with right now. I know this is hard to do, but I would like for everybody to try to take some deep breaths and move forward professionally. A lot of what y'all are talking about doesn't make it any easier, but it happened a month ago. I know tempers flared all around, but we need to move forward with this in whatever way it's going to move forward in a calm and professional manner, okay?
How do you be calm in this situation? It's been 19 months of a shit show of a trial.
I'd also like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level an assertion that Mr. SCHARDT is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Okay, well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well.
Wait, so her saying that, honestly, yesterday I thought this judge wasn't going to grant a mistrial based on her attitude, but it wouldn't surprise me, dude.
Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that.
I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's got it.
Thank you, Your Honor.
He's talking about the motion that I read in the video before this video. I had to record that earlier.
But I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. Like Mr. SCHARDT, I'm extremely upset having read that transcript. Myself and my fellow outside agitators over here, I assume that they are upset as well. And
I don't think, honestly, I don't think that that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
Well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't there, we don't have a video of it, so I have no idea specifically if that was not referred to us. We don't know, do we? We don't know. What I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability.
He was. Remember the interview that I did a video on? He even was like defending Glanville, saying Glanville was like a good guy and he probably just made a mistake here.
On the evidence and the law before him, and now I have been made to look like an idiot. So
well,
I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say, I haven't, obviously you just filed it and I haven't had a chance to look at it yet, but I will consider that in the overall context of the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are. If y'all feel like you need to get it off your chest, come on. Now's the time.
I got one more thing to say. And then I'll sit down.
That was funny as shit.
And I don't believe that this is performative outrage, Your Honor. I
mean, I don't either.
Okay.
I don't either. I already said I understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was? I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, it's coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial.
Great point. Why wouldn't it be higher? It's someone's life.
Bill is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right. Well,
What do I say?
I don't know. Obviously, I don't know what to say right now either. But I think that, while again, I understand frustration, let's be careful about disparaging a respected judge.
Is he respected at this point? Like, let's be realistic. Who is he respected by at this point? I don't know if he's respected at all.
I don't think you're wrong that he has been trying his best and doing his best. And,
Your
all
Honor,
right.
those were not my words. Those were Chief Judge Lando's words. If this was a civil trial.
Well, I don't know why it was. I don't know what evidence you're talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides. I will look at the 2 transcripts and I will make a ruling.
She seems a little flustered right now. If I was her, I'd be like, dude, I can't do this. This is going to be the next year of my life. This.
And again, I don't think that the characterizations are exactly accurate. But I'll consider it all in context and I'll make a ruling. All right.
Uh-oh, Brian Steele wants to talk.
Really had an overall objection because the witness testimony, which is before the afternoon of June 12th of 2024, he agreed that he said these prior statements. So over objection, and the way I understand the law, the state shouldn't have been able to put it in at all. So I understand what you're doing. I just want you to know that we're not conceding that I don't believe that it should come in at all. So before you, hey, why'd you make me do that?
No, I understand. And I think that Mr. SCHARDT had actually put that particular objection in writing in one of your filings anyway, essentially that to the extent that Mr. Copeland said, yes, I said every one of those things to police officers, but every one of them was a lie. That is an admission that he made the statements. And the defense position, as I understand it, is as long as he acknowledges the statement, then nothing else is a prior inconsistent statement. And I'll hear from the state with regard to that. But
I have one thing. Just another layer of that. Oh, I'm sorry.
go ahead.
Just another layer of that is the subject matter of these statements is largely the alleged co-conspirator statements that our stance is that those were not in furtherance of conspiracy either. So
Okay.
there's like 2 layers
Sure.
of analysis.
Okay, thank you.
I'm sorry for interrupting.
You asked, I let you.
I like the judge's attitude. Like, no matter what, she seems like way better than Glanville.
Regard to, does that make something said that is inconsistent in a prior inconsistent statement? And the state can provide me the law on that. But I think there are times when either an I don't remember or an I don't know or a well, that was a lie can still form the basis of making something a prior inconsistent statement.
So she just basically said right there, Woody's saying I don't know to the question. She still thinks that's a prior inconsistent statement, so it can come in. She basically just ruled right there.
I don't remember anything that I told the police. I keep telling you I don't remember anything. But if they say I said it, then I said it.
Yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that, and it was a flat out lie, and I'm paraphrasing, but that is what they're talking about, correct?
If that's what they're talking about.
Is that what y'all talking about, Mr. SCHARDT, Mr. Steele? Yeah.
I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement and to come in. Give us a moment just because we need to.
I mean, y'all, when I told you a week and a half ago that I wanted to be going through Mr. Copeland's evidence, y'all had 10 days or more to get ready for this. So I don't know what y'all thought we were going to be doing, but yes, I'd like to hear it. So if you need a minute to give me the law, go ahead.
I mean, what are we doing here? We need to be prepared, boys.
So objectively, he will go through the emails for the court that were misrepresented by Lawyer Love. I'm making a record, God forbid there's an appeal as well as for your consideration in this case going forward about calling Judge Glanville as a witness, that he spoke with Lawyer Love. She knew that he represented Mr. Copeland. Lawyer Love said that she did not know that he had denied representing him, Mr. Copeland.
That Mr. Copeland had denied that Mr. Melnick represented him.
No, Lawyer Love stated that John Melnick had previously denied representing Mr. Copeland to Judge Glanville. And that goes to the heart of why is there a ex parte meeting in the first place, because I don't know why there was. If it was done in open court, I would have been able to be there to question Mr. Copeland. I would have been able to be, because the Judge Glanville said, do you want to be, you have questions for your lawyer, the state, or me? If I was there, I assume he would have said, or Mr. Steele. And then people were asking him questions. They were discussing his testimony. Those are things that we had a material right to be present for. So the point I'm trying to make is
I'm
John
going to make a
Melnick.
substantive ruling with regard to that, and I don't know how Mr. Melnick is going to add to that.
Because
I mean,
if
it is clear to me from reading that June 7th transcript that the questions they had, I mean, they knew he was that because Ms. Hylton said when Mr. Copeland asked to talk to Ms. Hylton outside of the courtroom, and they were about to talk, Mr. Melnick either was there or appeared, and Ms. Hylton said, "Oh, you seem to want to talk to him, so I will let y'all talk privately," which, if she didn't think Mr. Melnick were representing Mr. Copeland, wouldn't have done. I mean, there would have been no reason for her to do that. I think that it is clear in context that what they meant by, we've got questions about whether he's representing Mr. Copeland is, and they said it, we have questions about whether he is representing Mr. Copeland's best interest, which as a lawyer, you are always supposed to do for your client. So I don't think they meant, literally, has he entered an appearance for Mr. Copeland, or has he represented to us and to the outside world that he is counsel for Mr. Copeland? It was, is he really acting in the best interest of Mr. Copeland? That's what they said they wanted to research and then meet with, or potentially meet with Judge Glanville about.
On the 10th, Lawyer Love said John Melnick, the Honorable John Melnick, stated that he was not representing Mr. Copeland. And Mr. Melnick said that is just a flat-out misrepresentation of conversation.
Okay, well.
So I just want to get the record straight, because Georgia law, and I gave you these cases in a footnote, Georgia law right now, and I know I'm very familiar with the Honorable Courts. So I want to make a record of showing it was prejudicial because they were knowing misrepresentations to even have a auspices of a meeting with.
I'm not sure if I follow you, though, with regard to, I need to establish that Mr. Melnick was in fact counsel for Mr. Copeland, because even in the June 10th ex parte meeting, Ms. Bumpus was there as stand-in counsel for Mr. Melnick, because apparently Mr. Melnick had said he had a pre-scheduled vacation or something like that, which everybody knew about on Friday or before Friday. And they were saying, you know, how can he actually be representing him, i.e. the best interest, if he's off on vacation when this critically important thing for Mr. Copeland is going on? But here's his standing counsel, Ms. Bumpus. So they understood that technically, at least, Mr. Melnick was representing Mr. Copeland. So, I mean, that's, I can take judicial notice of that to the extent I need to.
I'm inarticulate.
But why did she say at one point that he wasn't representing Mr. Copeland?
I believe it's going to have testimony before your court for you to judge credibility.
Okay.
That what was said out of the mouth of the two prosecutors, Hylton, Love, are not true. There's no emails to back up what Love says. Ms. Hylton, there's not this Mr. Copeland, I need to speak with the DA. Those things have been unrebutted. They're just being said. And my point is, without that, then why are you questioning another lawyer's ethical duties? What gives you the right to say that to the judge? And then the courts need to know that's not true.
All right. Just like I said to the state essentially yesterday with regard to their motion that suggested that defense attorneys were violating bar rules in the way that they talk to the press, I am going to suggest to the defense that attorneys for the state are violating bar rules in the way that they talk about defense attorneys or in representations that they make to the court. That too is something that they may have to deal with the state bar.
I'm dealing with, and my concern is Mr. Williams. So I'd like you to make findings, because I think that they go to the heart of, you're entitled to ethical prosecutors. We demand that. Ethical lawyers, ethical prosecutors, and a fair tribunal. That's constitutional, a fair tribunal. That did not happen here.
Whether what the prosecutors represented to Judge Glanville was true or not, maybe an issue for another type of tribunal.
She's just trying to push it on. She just wants to keep going on. She's like, whatever the prosecutor said to Glanville, I don't know what to tell you. We're moving on. He's off the case. So now we're talking about the prior inconsistent statement again with Woody.
When it asked Milton twice if he recalled making the statement, and Milton responded first that he could not recall making the statement, and then that he did recall but had lied.
Okay.
Discusses primarily that the state does not now have to go through every single inconsistency,
okay.
But that we can now, the flat-out denial of that statement, Your Honor, allows us to move forward in playing the entirety of the statement, Your Honor, without going into further details. That's kind of our summation of Scaniers.
Right.
Ms. Hylton basically just cited some case law where they're allowed to let these statements in. Woody saying everything I said was a lie allows the state to bring the statement in. Defense has been objecting to this forever, literally for months. They say it's not a prior inconsistent statement.
So it looks like defendants, appellants now at, the appellate stage are saying, hey, a prior inconsistent statement is admissible only if I deny making the statement, not if I simply say it wasn't true. And the appellate court is saying, no, that's not correct. You don't have to deny it. Even without a denial, it can still come in. That does not mean the flip is true, that the other part, not simply if he disputes the truth, is not a way to get it in.
I agree.
So, I mean, you can take a look at Green, but Green seems pretty on all fours.
So she seems convinced that she's going to let these statements in, obviously, but Woody has to testify the same exact way for the statements to come in, which he probably will testify the same exact way and act dumb. People got offended that I said Woody was acting dumb, but I think he was acting dumb. Like, he clearly remembers some of this shit.
I don't remember whether he says, I never made the statement, or whether he says, yes, I made this a total lie. All three of those, it appears under our current state of the law, would permit then the introduction of prior inconsistent statements under 613.
Quick update on Woody's life. He's been having some fun in Atlanta.
Don't get scared over there. What you doing? God damn.
Just in a public parking lot causing havoc.
Tell free YSL.
You said tell him free YSL, screaming at people around him.
Did anybody say so? You did. We ain't going back and forth.
nutsack. 12 might pull up. I gotta run with that money.
12 might pull up. I gotta run. Put it in my nutsack. Cuts back to the courtroom being all quiet and professional.
January 28th, February 20th, and February 21st interviews.
Okay.
We do not have any issues with the redactions as is.
Okay, and those redactions being something that the defense and you all have agreed to? Hashings out done prior to or after the recusal motion being filed?
It was done, 3 of them were definitely done after the recusal motion was filed.
Okay. Well, the one done before the recusal motion was filed, we can go with. However, that ultimately ended up being redacted. Either needs to get redone or y'all need to make a, come to agreement on.
All the Woody interviews had a shit ton of redactions they did with Glanville. They took stuff out that the defense didn't like. The state is fine with having the same redactions they had before. I'm sure the defense lawyers aren't going to like any of this. Let's see what Max SCHARDT says about the redactions of the Woody interview.
Trial judge was not an impartial judge.
I understand.
And so we don't believe that the issues are just limited to post serving the recusal motion at this time.
Okay.
So that's, and we understand.
I am not going to be going back and revisiting evidentiary rulings made before then.
I understand.
So he's saying since Glanville was not a fair and impartial judge, he doesn't agree with any of the rulings. She's not going to change any prior rulings. This trial is
I think what Mr. SCHARDT is saying, and if he's not saying it, I'll say it, that we really need some time to kind of get all that together.
All right, y'all. When I met with y'all, when was that? Friday, a week and a half ago, and said, okay, here's how we're going to move forward. And then gave y'all 10 days or so to, before we had our Tuesday, hey, we're doing motions now, and then we're going to move to evidence.
The state didn't follow that rule. They were following shit on the Monday when their deadline was Friday before.
Y'all should have used that 10 days to be doing this because we literally talked at that time about we're going to need to go back through some of Mr. Copeland's evidence. Y'all may have a really long night tonight. I do not want tomorrow to be as unproductive as today. All right, so how about another witness? If we can't work on Mr. Copeland right now, is there some other witness that we know is going to also have a lot of evidence that is going to be contentious?
It's a good question. Let's move on from Woody.
Mr. Zachary.
Evidentiary issues we think are likely to come up at trial, and then we will go ahead and hash those out. So yes, obviously it's a contingent ruling, and have taken a look at them and know what you think is going to be potentially objectionable. If y'all want to give me those statements, make those objections, I'll hear a response, and then we can try to get through that. That would be great.
So them talking about quindarius ZACHARY. George Cheedy, a really good reporter, I believe, from Atlanta. He tweeted this at one point. He put up a whole thread about YSL. The police began to match all the shootings to a small number of guns. When cops arrested quindarius ZACHARY, he talked, leading them to the guns.
Okay, so is anybody ready to go on Mr. Zachary? Anybody?
Thousands and thousands of pages, and probably thousands of pages of transcripts. So I didn't know that Zachary's statements were going to be on the agenda for today, so I didn't bring the transcripts with all my notes.
I mean, they shouldn't have been on the agenda because Kenneth Copeland was the agenda today. But okay, I hear you. You're not ready, but you can be ready soon.
And I'm estimating here, I would say a total of about 9 hours of talking.
Quindarius ZACHARY got 9 hours of talking to the feds.
For instance, do you intend to use the entirety of all 3 statements? And if not, could you pinpoint for the defense what portions of those statements you intend to use so that if they have an objection to something you're not going to use, they don't even need to look at that because you don't intend to use it.
We can, and then we'll be coming up in the next batch of 30 witnesses, so we can identify.
What an insane statement. It's coming up in the next batch of 30 witnesses. That's just another batch. There's tons of other batches of witnesses we have here. We're already 19 months of the trial.
On behalf of Mr. Nichols, a continuing objection to the admission of any of these statements, in that they have absolutely nothing to do with Mr. Nichols. Well, it required the state to provide to the defense all of the 801D2E statements that the state contended it would seek to admit during the course of the trial. That notice was filed on or about by the state on or about, excuse me, November 3rd. They only noticed three statements.
Hold on, what? The state only put in 3 co-conspirator statements total? There's way more than that, I'm sure of it. And apparently Glanville ordered that they can't put more than 3 statements.
They do now, after a year, after 19 months, after a specific motion, after specific requests by every single defendant so that we could hash this out. A year ago, they gave us 3. So I'm going to object to any other alleged co-conspirator statements that the state seeks to admit under 801D2E.
Have more than that now, and if so, tell me why those should come in despite not being included in the November notice.
So, Your Honor, the November notice, we stated that the state will establish the ongoing conspiracy of the YSL criminal street gang at trial, and any statements made between co-conspirators in the YSL criminal street gang conspiracy that were made in furtherance of the conspiracy are admissible, and we request the court grant the state's motion to permit these admissible statements at trial. What we've seen come up, for instance, during jail recordings, there are persons who are not indicted under this indictment as a co-conspirator that make statements to either a witness or a defendant currently on trial.
Which I think is insane how they're allowed to do this. Someone that isn't indicted, just because they're a co-conspirator, their statement comes in. They're not even in the trial and they can't even be cross-examined. Defense can't do anything about it.
What notice does the defense have of specific statements that are not included in the November 3rd, 2023 notice?
So she's trying to peel back the pages here. She's like, so have you given over all the statements? Or have you not? Have you not done what you're supposed to do?
Because it's one thing to say broadly, hey, if they're co-conspirator statements, we intend to use them. It's another to say, and here are the ones we intend to use. And if the court had ordered, you need to tell the defense which of these you intend to use, then it's time to get down to specifics.
Yes, Your Honor.
You provided notice of 3 different statements.
Right, 3 specific ones.
Okay,
yes.
Right?
Yes.
All right, so my question is, are there other statements besides those 3 that you believe are admissible in the trial of this case as to any witness?
There are. Just one moment.
All right.
Miss Love is showing her booty cheeks to us right now, dude.
There are many. There are many that are included in the...
So another co-conspirator thing could be confusing. Here's the rule right here, 801 D2E. To admit a co-conspirator statement under this rule, the following criteria must be met. Existence of a conspiracy. Court must find there was a conspiracy involving the declarant and the party against whom the statement is offered. This does not mean that the conspiracy must be proven beyond a reasonable doubt, but there must be sufficient evidence to demonstrate its existence. I remember Glanville saying there's sufficient evidence of a conspiracy. Statement made during the course of the conspiracy. Statements must have been made while the conspiracy was ongoing. Statements made after the conspiracy has ended may not be admissible under this rule. The statement that Demikian said to Woody was during the conspiracy. Statement made in furtherance of conspiracy. Statement must be made to help achieve the goals of the conspiracy. Casual remarks about the conspiracy may not qualify. Essential tool for prosecutors, enabling them to use out-of-court statements made by conspirators to prove the conspiracy's existence and objectives. I don't like that rule at all, but I hope that clarified it for you guys.
Okay, now tell me what other statements you believe to be co-conspirator statements and why they should come in now when you were ordered many, many months ago to tell the defense what they were.
Sheesh! That's what I'm saying. Why are these allowed in if you were ordered months ago, huh?
They are included as part of the jail calls and the wiretap.
Okay, so they have them. They just haven't been identified as, hey, we think this is a co-conspirator statement, we intend to use it. At least as of now, really well before now, you should have identified, here's what we're actually going to use. Whatever co-conspirator statement you know of right now, let's stand up and let's share it with the rest of the people here so that they can then...
There's probably hundreds. They're not even going to be able to do that.
Tonight, look at it and say, here's why it's not. And for anything that you don't know of right now, you need to go home tonight and huddle together and figure out what else there might be. And I will consider whether I'm going to let that in or not.
And so that the court knows what I'm doing, I overheated. And so I had to...
By which you mean your laptop overheated?
I do mean my laptop. And I was...
Because I've told y'all not to overheat anymore.
Come on, Miss Love. You can't go out and get a new laptop then. You should overheating in 2024. So we just took an hour-and-a-half break, I guess, for the state to get together all the co-conspirator statements.
So you can identify the statements, and you're saying that it may be less than the full statement, and you can further narrow that, but you at least at this point have the person and their statements. Okay.
My original objection was too little, too late. In other words...
I understand.
Okay.
I'm just trying to sort out what there even potentially is at this point, and then, which is...
I love Mr. Harvey, bro. He seems like a nice guy. Pro said too little, too late. They can't come in. The fact that we're sitting here wasting this much time on identifying what witnesses are co-conspirators in the case 19 months into the trial.
Mr. Stillwell to Mr. Zachary, that we caught nut down bad. And then another statement allegedly made by Mr. Kendrick to Mr. Zachary saying we caught nut down bad. Is that correct? Those are the entire co-conspirator statements to Zachary that we're talking about right now.
Judge.
Yes.
Zachary's interviews, the entirety of those interviews and everything that he alleged that a co-conspirator told him in those interviews are statements of co-conspirators we intend to use in this trial. So he has said, and we identified that because I thought it was pretty specific as it related to the Donovan Thomas murder, what it is that 2 defendants currently on trial are alleged to have said. Okay. But within those interviews, he talks about other co-conspirators and acts, for instance, the shootings, the buying of the shootings of one of the incidents that are alleged as an overt act in this indictment. He talks about his role providing guns to members of YSL.
Okay,
and
so the answer is no, it's not just those 2.
Right, it's the whole statement.
No, it's not just those 2.
Right.
And so,
my understanding is the state is saying, and I don't know if this is true or not, but the state is saying at this point, to the extent that they know, Mr. Zachary's taking a stand. So that's what I understand him saying. And so him saying that he provided guns to people is not a co-conspirator statement if he's taking a stand. I'm saying what the state is saying is a co-conspirator statement involving Mr. Zachary. The only thing we've told that has been identified to us is those two statements, which are clearly, in my opinion, spilling the beans. I mean, we're in the same predicament as that's going to be our stance, but I don't know. I can't answer to other statements that have not been identified specifically.
that anything that they say to anybody is a co-conspirator statement, potentially, because they're co-conspirators with the other co-indictees. And anything that they relay was said to them by another either indicted person or person who has admitted in judicio to being a member of this gang is also a co-conspirator statement, and that the defense is basically on notice of that anyway.
If it is contained within an interview that we have given to them,
Okay.
yes. If it is a statement that is made to someone alleged to be YSL, yes. If it is a statement
Not just alleged to be YSL. I mean, if you're saying they've got automatic notice of this, it needs to be more than somebody's alleged to be YSL for them to, if you're saying, hey, my notice already based on this indictment and me giving these statements over is sufficient notice.
The reality is these statements, for instance, Mr. Zachary gives a proffer. There's like 4 district attorneys and probably 4 investigators in the room with Mr. Zachary and his attorney. The district attorney, really the investigators are just peppering him. Well, tell us about the Lil Wayne bus shooting, or tell us about the shooting on, someone's house. And these aren't lawyers asking the question, and there's no indication of what he's basing it on, who told him, who he's saying told him.
Right. So you need to know in more detail. Is the state planning to use, I think Shannon did that.
Right.
Is that what you want to know, so that we can then drill down on, is there any basis for that coming in?
Right. I need to know what the statement is. If the state knows, now obviously if the statement says, Mr. Huey told me this, then I understand that he's saying the source is Mr. Huey, but there's just so much information that's just like being thrown out with no identified declarant.
Sure. Okay. So first things first is you identify within the next week what parts of each statement you intend to use, because it may be that you are not going to use, I think Shannon did it. And so if that's the case, we won't worry about it any further. So identify them. And if you can also, before the end of the week, before a week's time is out, identify the source if it's not readily apparent, do that as well, but at least get them each statement. And so we'll go from there.
I argued this before the recused judge, and it was denied. The indictment is fatally defective.
Okay.
So this is the motion he wants her to reconsider that Glanville denied back in November of 2023. Basically, Brian Steele says the indictment isn't worded correctly. They're missing language that they needed in the indictment.
Flying through the Fulton County District Attorney's Office did not allege a material element. There are 4 material elements.
So there's 4 elements and they're missing one.
And there's going to be a jury instruction that the court, one day is going to give to the jurors. There is a jury instruction on this crime. There's also case law that one of the essential elements is that the crime was committed to further the interests of the gang. That is omitted in count numbers 56 and 57 for Mr. Williams.
So you said that with regard to counts 56 and 57, it is not alleged.
I promised that.
Okay. And are there other counts that are alleged against your client, Mr. Williams, where that is an issue?
Yes, there's an essential element in count 1, which is the RICO count. And I compared it. I just did it because it's such a well-known case to the Donald Trump indictment out of the same.
So I remember him comparing this to Trump's whole RICO thing.
Nowhere in count 1 will you see that any of these individuals have been charged with joining the conspiracy knowingly and willfully. It is not in there.
Nowhere does it say knowingly and willingly joining the conspiracy.
I went through it hard. There is no allegation by the grand jury that Mr. Williams or anybody knowingly and willfully joined the conspiracy. And under Cotman, which is COTMAN versus State, Court of Appeals of Georgia held that in order to commit conspiracy under the RICO statute in Georgia requires proof of the material element that the accused knowingly and willfully joined the RICO conspiracy. That under Georgia law, a person may be found guilty of the crime of RICO conspiracy if that person knowingly and willfully joined the conspiracy which itself contained a common plan or purpose to commit 2 or more predicate acts.
So he's citing 2 cases here to support his claim. All right, that's pretty much it. Another ex parte hearing. Defense lawyers are not happy, and they barely got anything done today. I'm going to be honest. Hey, subscribe, join the channel membership. It's only 10 cents per day. Love you guys. Peace out.